the right to a speedy and public trial, that's enumerated in the Sixth Amendment, correct?
Absolutely correct.
And what about compulsory process and confrontation? Is that Sixth Amendment? That's enumerated in the Sixth Amendment.
The confrontation clause and the right to confront witnesses against you is a Sixth Amendment right. Here's one of the pieces of the puzzle that's kind of interesting. You have various protections under the Bill of Rights that show up in different places. So the Bill of Rights is not perfect when it comes to working through a chronological notion of your rights. So bail, pretrial right, shows up in the Eighth Amendment. Meanwhile, various trial rights may show up in the Fifth Amendment, some in the Sixth Amendment. Some post-trial rights show up in the Fifth Amendment. It's a melange, but it's one that we see out there. So confrontation, the confrontation clause, the notion that you can or are required to be able to confront witnesses against you, has its genesis in the Sir Walter Raleigh case from the early 1600s. Obviously before our United States was formed. In that situation, Sir Walter Raleigh, he was on trial, I believe, for treason, in a situation where folks who can't come in front of him and tell their story in front of him instead were questioned in other places, and their information was taken in the trial against them. And his notion was, I should have the right to confront these folks who are charging that I engaged in treason or in behavior that was contrary to the crown. And the notion was, well, that seems like a good idea for us, so that's where the confrontation clause ends up in the Sixth Amendment. We say it cannot be the case. It cannot be the case that government can grab information from witnesses who can't show up and actually testify to what they're saying in front of you. It's important that those folks show up in trial. It's important that defense has an opportunity to cross-examine those individuals, because the notion is that we want to get toward the truth in trial. That's the notion behind the confrontation clause that's embedded in the Sixth Amendment.
And the compulsory process is the means by which you can compel people to come?
Absolutely correct. The compulsory process piece of the puzzle gets them to court. If you can't force them to come to court, then it's going to be very difficult to get them in the chair and cross-examine them. So that is a way of getting folks to court so that you can then discharge your confrontation clause. Well, I won't say discharge, so you can then assert your confrontation clause rights.